fixed for today. It did not come on the list.
You make a mention. Give a mention, Memo.
Mention he got Will you, are your lordships keeping it for today?
We'll just speak to the registrar and then tell you after some time
Very good.
at 12 o'clock, because today again there is a official program.
Okay.
On which Justice Abhay Okaji and Justice Ujjal Bhaiya will be here.
Okay.
They have a meeting at 5.
Oh, so then your lordship.
Maybe perhaps because of that, we don't know. We'll just have a
Then
word with
your
the registrar
lordship
and tell you.
let's fix a date.
Have a word and 12 o'clock we'll tell you.
Right.
If not, what is your next convenient date?
I
For both
was
of
in April first week. A Monday doesn't suit your lordships. Okay.
Tuesdays and Thursdays are preferred.
Preferred.
Very good. And then the 2nd of April.
Okay.
Great. I'm grateful.
What are you?
I have your lordship. I'd like to mention for listing, lordship. NFT
Which you
W
give to the
lordship.
courtmaster. Yes, for listing. Give it.
Wait, Mr. Lordship. My lord, I pray for listing of an IA.
We got item number 5, my lord. The matter will be adjourned for a day, my lord.
Okay. Both sides are represented. On the prayer made by learned counsel for the petitioner, the matter is adjourned today, list after 2 weeks.
I'll have it.
Your lordship, I'd like to mention for item number 15, kindly adjourn for the day.
Item number
15.
15, we are not adjourning. Tuesday and Thursday without advance information, we are not adjourning any matter.
Only for the day, my lord. Only for the day.
No. Prayer is refused, we'll renew the prayer when the matter is reached.
Only
Not
for
now.
the day. Tomorrow, my lord.
Tuesdays and Thursdays, we are not adjourning. Without prior intimation, we are not adjourning any matter.
Well, Monday, my lord. Fix my Monday. Only for the day, my lord.
We renew the prayer when the matter reaches. We will not adjourn it like that.
Daily list item 1 for motion.
My lord, the opinion, lordship will find at page
Just a moment.
116.
Just a moment. Page number?
My lord, 116, and it's at 21. Judgment dated 23/9/24.
23/9.
23/9.
Okay, we are granting bail.
My lord,
Mr. Sharma, we are granting bail.
31 is judgment, my lord. By the
Oh,
time-
don't worry. We are accustomed to that. One of the judgments which I authored for the division bench runs into 550 paragraphs. Few days back only, we had delivered 550 paragraphs. So volume does not deter us. Had Mr. A.R. Sigdal and counsel for the petitioner. All the respondents are there, Mr. M. Islam on behalf of AIL or ECI. Audit at page 116. Opinion dated 23/9/2024, passed by so and so and so. They were declaring the petitioner to be a foreigner post 25/3/1971. Notice returned within 4 weeks. Extra copies within 2 days. All for the records. The prayer for bail is opposed by the Honorable Standing Council for the FT matters. Grant bail, rupees 5,000 to be taken within 10 days before the Supreme Police border.
Borpatang.
Borpeta. Just talk about this on the side.
Supply item 16.
Lordship petitioner prefers this repetition challenging order dated 19 January 2024, Your Lordship. And
Where
it
is-
order is at page number 118, Your Lordship.
118.
18, Your Lordship. 118.
But you'll have to wait for some time for bail. You crossed 1 year. You have to wait for some time for bail.
Lordship, I sincerely apologize for a mistake I have made at page number 227, Your Lordship.
27.
Yes. At para number, at second para, Your Lordship.
Yes.
I have submitted to the learned DW2, Your Lordship. I have written DW2 instead of DW3, Your Lordship.
Okay. We'll permit you to correct it. Heard Mr.
I hope, Your Lordship.
I Hawk Learned Counsel for the petitioner. All the responses are same. The opinion is at page 118. Dated 19/1/2024. Passed by so-and-so in case number so-and-so, reference case number so-and-so. Thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. If you notice, give a date after 4 weeks. As returnable on so-and-so. Requisite extra copies of the writ petition be served on the London State and CCC State and Department of Constitution in 2 days. Let the relevant records be requisitioned from the London Tribunal. Next, the prayer for bail shall be considered on receipt of the records of the tribunal. Next, in the meanwhile, if the petitioner is apprehended, she shall not be deported out of the country without order of the court. List on 23rd April.
That's a mistake.
Yes.
That's a mistake.
Okay. Just before that, you said on the prayer made by learned counsel for the petitioner is permitted to make necessary correction in subpara 2 of page 27 of the writ petition by substituting DW2 as DW3. Do it now.
Oblige, Your Lordship.
Please make correction in the copy of Mr. Sharma also.
Lordship.
Do it and correct it.
May please, Your Lordship. My Lord, here in this case, my Lord, we have a point, my Lord, about the maintainability of the proceeding.
Yes.
My Lord, inquiry was against Abdul Mutin, but the petitioners, against the petitioners, no inquiry.
Okay.
In the light of the Sudhir case, my Lord, it's not maintainable, my Lord. The proceeding itself is not maintainable. We have the copy of
We'll
this.
just examine it.
Lordship, may kindly have a look at the inquiry report, my Lord.
Yes. Yes.
Form 123. This goes to show that inquiry was against Abdul Mutin. No, it's against these petitioners, my Lord.
No.
कौन है वो? ओ, ना जाने ओए, जाने सर क्यों दिया सर বিচাৰিলে দিম। দিয়া আছে আৰু 2 দিন মান আগতে দিছো। বিচাৰিলে দিম।
Oh,
2019 2 May I serve the copy, my lord? Yes. Yeah. My lord. Sudhir Roy. Paragraph 9, my lord.
good process, no famous.
Hmm?
Proceeding cannot go beyond the sanction.
There is something that's case.
To it was to help to believe. So do you know about it?
Well, I will go to this. Nothing.
No, absolutely. There is.
Sudhir is sufficient. Yes, Anu.
Copy pata hai reference.
But I'm also to be 9 with effort cycles.
Which is the opinion, Mr. Sikdar?
My lord, opinion, lordship will find at least 70.
76.
Page 70, my lord.
Pardon me?
Sorry, my lord, it's page 60, and a 13. In the order also, in the first paragraph, noted that the inquiry was only against Abdul Mutin.
And this, the first proceeding at page 60, Abdul
Right.
Motin,
My lord,
he has filed a separate writ petition or
no, my lord, no. No, my lord.
he is not
At
filed?
the time of declaration, the Mutin has expired, my lord.
He has expired.
Expired.
But then you still have a risk.
My lord.
You see, these petitioners,
But
they-
he has also been declared foreign. Abdul Mutin has also been declared.
so therefore, you see, that will haunt the other legal heads. Once Abdul Motin is declared to be a foreigner and that opinion is not challenged, this opinion will haunt them.
My lord. Hmm.
Yes.
But they were not the
No,
party
it's
in the
okay.
case.
We are accepting our,
My lord.
we are accepting our statement, but there is an inherent risk involved that we are trying to tell you.
My lord.
It's
Yes,
not there.
yes.
We set aside this opinion insofar as the petitioners are concerned.
Yes.
Let it be set aside if the fresh proceedings, then they will contest the case, my lord. Otherwise, on merit also, my lord, their case is not bad.
No, it's
Grandfather is-
okay.
My lord,
We go by your choice
my lord,
instead of multiplying our work.
my lord.
Heard Mr. A.R. Sigdal under counsel for the petitioner. The respondent is the same. Next, by filing this writ petition under Article 226 of the Constitution of India,
Party.
the petitioners have assailed the opinion dated 28/2/2019, page 60. Passed by so and so in there are three case numbers, huh? In so and so, old number so and so, arising out of so and so. They were declaring them to be, they were declaring them as well as one Mohammed MD, Mohammed Abdul ABDUL, Motin MOTIN, son of late Nasaruddin, NASARUDDIN, one word, Nasaruddin, as foreigner who have entered into India within bracket Assam after 25/3/1971. So the said opinion is assailed on the ground that as per the records of the learned tribunal, the border police under the superintendent of police within bracket border, bracket Morigaon, did not conduct any inquiry against the petitioners, and that the inquiry was only directed against Mohammed Abdul Motin. So, in support of his contention, the learned counsel for the petitioner has relied upon the decision of this court in the case of Sudhir Roy and others versus Union of India and others, 2019 within bracket 2, bracket close GLT 6-1. Next paragraph. On a perusal of the records of the learned tribunal, the court did not find any inquiry being directed against the present petitioners. And the reference made by the superintendent of police within bracket border, Morigaon, white memo number, white memo under F full stop T full stop C full stop number 431/10 dated 29/11/2010. But by which inquiry was initiated was only directed against Mohammed Abdul Motin. First of the interrogation report under form Roman 1, form Roman 3. No, 2 also, form 1, form 2 and form 3 are also in respect of Mohammed Abdul Motin. First of how in column 13 of the interrogation report under form 1 contains the name of the petitioners as other family members of Mohammed Abdul Motin. However, in the report of the Superintendent of Police, Border Morigao, dated 29/11/2010, the said authority has mentioned that the person, i.e., Mohammed Abdul Motin, and his family members entered into India after 25/3/1971. So, be it mentioned that the border police had only taken the fingerprint, photographs and the statement of only Mohammed Abdul Motin and no one else, including the petitioners. So, Sharma, please see this. Where is the forwarding of the reference? The reference must be made to the court,
Yes,
tribunal. Where is that memo? That small slip is for
Yes.
causing an inquiry.
yes.
There's no reference at all.
Yes, Lordship, this page, Lordship. Page 10, Lordship, backside 11, Lordship. This is SP reference, Lordship.
But down below, he has not signed it.
Yes,
Actual reference was never signed by him.
yes, yes, yes.
1 to 13 is a report.
Yes, yes.
But where is the reference?
No, not signed by SP.
Yes, Lord. Yes, Lord. একটু কি দিছে? একটু কি discuss করছি? একটু
Complainant,
কোন-
suspect, এটা রেফারেন্স থাকিব লাগিব নহয়
কোন ক্ষেত্ৰত?
রেফারেন্স তো নহয় এইটো এইটো আপোনাৰ কোনে সাইন কৰিছে
এইটো forwarded to SP border দৰং যোৰহাট
তেওঁ ফৰৱাৰ্ডহে কৰিছে
উম।
ৰেফাৰেন্সত সাইন থাকিব লাগিব তেওঁ ধৰিছে এইটো
SP border মৰিগাঁও so inspector forwarded to
এনকোয়ারি কমপ্লেইনমেন্টটো এসপি হৈ পাৰে কাৰণ কমপ্লেইনটো এনকোয়ারি কৰিব দিছে এনকোয়ারি কৰি ৰেফাৰেন্স
কিন্তু SPF forward কৰা হেৰিখন নাই
So reference is directed. No case is maintained made out. Still.
could not find lordship.
Mr. Nath. This is not for Mr. Nath.
Yeah.
In this, we are relying on you, but we have something else to say to Mr. Nath. Mr. Nath, you remember we had a talk with the police authorities. Few months back, we had a meeting. The DIGP and all, they were there. I think we have to continue that for some time again. There are a lot of requirements coming in, and my esteemed sister has just now said that perhaps for the NDPS, the police would require more rigorous training. The manner of preparing the seizure memo, the grounds to be given. That's what my sister was telling. So I think that conversation we are having has to be continued further. Because if you take a call then perhaps I can put in a word with Honorable Justice Pathak, and then through academy we can have something.
Smaller. Can be done. In fact, my lord, the one PIL is pending that is relating to segregation of crime investigation and
No, we are not on that, but you see, these things are leading to another arena altogether. Because if the manner in which this NDPS seizures come to our notice, there are a lot of things to be done.
but right from the beginning, my lord, from the training itself of the officers for investigation. Ultimately, in the curriculum,
including
my lord, it has to be introduced.
Yes, yes. So I think we need to have more conversation with
Lordship,
the
lordship, lordship.
police on the point.
Yes, yes, my lord. Lordship may indicate, my lord, I'll
No, you have a word with them. Let them also. In Hindi we call it Gyan Manthan.
correct.
Let them have their own discussion, and then what you call, they should come up with a idea in which we can proceed.
My lord,
Because we have not made out our mind.
my lord. The materials which, my lord, on the in the last meeting, lordship has given in pen drive.
Yes.
I have seen, my lord, it's a very, my lord, after a thorough research that has been prepared, and it is very helpful for us, my lord. I have to ask them what they have done with that. I'll ask.
So, because we have to carry it forward for the
Correct.
second,
Correct. True, my lord, true.
and perhaps for that, since we have a Esteemed sister who has taken deep interest in the matter, especially with regard to the NDPS challenge and all, I think we should carry that conversation to the next level.
True, my lord. Lordship.
That's all. We can have a discussion with them whenever it's convenient to them.
I'll
We
advise.
can
Lordship.
have a further conversation.
I'll talk to them and I'll apply, my lord.
Because it has to be also included in the academic calendar of the Judicial Academy. So if a training course is required to be undertaken, for that we'll have to do some planning.
Lordship.
That's all.
I'll apply.
the tribunal's records was passed over to the learned standing counsel for the active matters to verify from the records as to whether any formal reference was made against the petitioners. First of all, moreover, as it is seen that the records also do not contain a formal reference by the Superintendent of Police Border Morigaon to the concerned foreigners tribunal, this is the second aspect on which the learned standing counsel for the FT matters was requested to peruse the records. Next paragraph. Not next paragraph, continue. Upon perusal of the records, the response by the learned standing counsel for the FT matters was in the negative. Next paragraph. Therefore, the court is inclined to hold that in course of the inquiry ordered by the Superintendent of Police within bracket border, Morigaon, the only reference was to the investigating officer was to inquire as, if the suspect Mohammed Abdul Mateen, aged 52 years, son of Nasaruddin, Nasaruddin, of village Saruchala, Saruchalla, PS Moirabari, in the district of Morigaon, is a suspect. He is suspected to be foreign national who has entered into India between 1/6/1966 to 25/3/1971 or after 25/3/1971. Full stop. The inquiry is not found to be made against the present petitioners. So therefore, it is held that there was no inquiry by the border police of district Morigaon against the present petitioners. Next paragraph. Insofar as a valid reference is concerned, on examination of the records, it is seen that at page 7 of the records, the Superintendent of Police Border Morigaon has directed the sub-inspector within bracket border of Moirabari Police Station to cause an inquiry. Full stop. The Form 1 of the interrogation report contains the name of Mohammed Abdul Mateen as the suspected foreign national. And he said, report is signed by the sub-inspector of police border. Stop. Similarly, in Form 2, the name of the suspect is Mohammed Abdul Mateen, and the said form is signed by the inquiry officer. Post of Form 3 regarding finding an inquiry report of the inquiry officer. The name of the suspect is again Mohammed Abdul Mateen. And in paragraph 22 thereof, it has been mentioned that during inquiry, it appears inverted commas. The IO is stated as to give a dash, then inverted commas. During inquiry, it appears to me in prima facie manner that the suspected person entered into India after 25/3/1971, and he could not produce any document in support of Indian nationality. First of hence, the case referred to the Honorable Tribunal Court for trial. Full stop, inverted commas closed. So the said report is signed by the Sub Inspector of Police. Full stop. The said form does not bear the counter signature of the Superintendent of Police. Now, they said form 1 and 3 referred above do not contain the counter signature of the Superintendent of Police border. Borigaon. Most of the said form numbers 1, 2, and 3 are at page 8, 9, and 10 of the records. So the records also contain an order by the Superintendent of Police, Border Morigaon, dated 29/11/2010, suspecting the petitioner to have, suspecting Muhammad Abdul Mateen to have entered into India after 25/3/1971, along with his family members. Nonetheless, the records do not contain a formal reference letter to the Foreigners Tribunal, Second Morigaon. Formal reference by the Superintendent of Police, Border Morigaon. Next para. This court, in the case of Sudhir Roy within bracket Supra, had held as follows. Para 2. Para 9. Ten and 11. Next para. Following the ratio laid down in the case of Sudhir Roy and others within bracket Supra, the court was of the considered opinion that though the learned member of Foreign Tribunal, Second Morigaon, has held Muhammad Abdul Mateen as a foreigner of post 25/3/1971 stream, but said opinion shall not lead to a presumption that the petitioners herein, namely give the names so and so, are also foreigners, unless due inquiry is made against them and upon reference being made against them, they are declared to be foreigners by the competent tribunal having jurisdiction. Next paragraph. Accordingly, in view of above, that part of the order of the impugned opinion dated 28 to 2019, passed by so and so and so and so, declaring these 8 names of the petitioners who are proceeding number 2 and 2 to 9, respectively, before the tribunal, who are declared to be foreigners of post 25/3/1971 stream, is accordingly set aside. Next paragraph is certainty, the said opinion dated 28 to 2017 shall only be limited to declaration of Muhammad Abdul Mateen, son of late Nasaruddin, as a foreigner of post 25/3/1971 stream. Next paragraph. According to the repression stands allowed to the extent as indicated above. Next paragraph, there shall be no orders to cost. Next paragraph, the registry shall send the records back to the learned the tribunal records back along with a downloaded copy of this order, so that it can be made a part of record of FT of case number FT 291/2016 within bracket new.
Lordship has, with a sharp eye, has seen the records and found that reference is not valid. That also has been recorded. But to that effect, the order is not given effect. Reference is not valid. The Lordship has seen.
No, you see that around, but that was not challenged by the party who's aggrieved. That's why I said,
Well,
certain technicalities must be left alive.
oblige Lordship. My lord, I have another item, my lord, item number 9.
But this is a very bad sign.
No, my lord, I normally I do not avoid the
Okay, which item?
only for the day. Item 9, my lord.
9. Okay.
9. Only for the day, my lord.
Okay. Item 9, Basel for the DS, wait for land council for the petitioner. Both sides are represented. Huh? Okay.
Deeply oblige Lordship.
Item 3.
Right, please, your lordships.
Yes. Custodial death.
Yes.
Earlier report was called for from first class judicial magistrate. Your lordship's called report earlier.
Okay, I don't remember. Original case record is received. It has come. Okay, that this is the matter we gave the records to. Oh, no. Yes.
Keeping the report to subordinate, it can be the case.
Yes.
Yes, my lord, before I start, my lord, in my endeavor to assist your lordship in a subject matter which I am not regular with, there may be shortcomings on my part, lordship will kindly control me. Now, my lord, the matter pertains to custodial death, and the petitioner before your lordship is the father of the deceased victim, my lord.
Yes.
Yes. My lord, since the incident happened in the wee hours of the night, and the two in the custody of the police authorities, my lord, the petitioner is only trying to, my lord, point out the discrepancies or contradictions in their stand, my lord, which cast a serious doubt in the, my lord, in the manner in which the death occurred.
Yes.
My lord, may I just place the facts before I
Yes.
take your lordship to the
Yes.
relevant documents. My lord, the petitioner's son, which is a deceased victim, Sanful Ali, was arrested in connection with Hajo PS case number 1993 of 2021, my lord, on 2/12/2021.
2/12/2021.
He was arrested on 2/12/2021 in connection with Hajo PS case number 1993 of 21. Thereafter, though he was on the pretext of
No, there is something we are missing. You said 2/12,
2/12/2021.
but as per page 6, something happened on 28/11.
Yes, my lord. A dead body was found, and he was alleged of he was one of the accused in the murder of that particular person, for which this Hajo PS case number 1993 of 2021 registered.
So 28/3, this man was kidnapped.
Kidnapped, and later on his body was found. And
What is the
accordingly,
name of that person?
my
Person who died on
once Sarbat Ali lodged the FIR that his son Safizul alias Babu,
Safizul.
yes, was kidnapped.
Yes.
Yes. So my lord, on once Herbert Ali lodged that FIR before the Hajo police station that his son Hafizul was kidnapped and later on murdered. And the FIR has been registered as Hajo PS case number 1993 of 2021. And in connection with that PS case, the petitioner's son was arrested on 2/12/2021, my lord. Subsequently, my lord, it is learned from the documents that, my lord, he was not kept in the Hajo PS police station. Rather, he was kept at North Guwahati police station. And the reason given for that is there was law and order situation, but there is no document to substantiate that. Be that as it may, it was
No, normally that will not be done unless there's a police report and the court will permit it. Because
yes, but there
on
is no
production-
documents to substantiate it. I will show that, my lord. But that is a categorical stand of the police authorities, because as due to law and order situation, he was kept at North Guwahati police station. Be that as it may, on interrogation,
just a moment.
my lord. Paragraph 6 at page 8, we have stated so, my lord. Paragraph 6 at page 8.
No, the police report itself says
Yes, police, that's right. I will
that this man was arrested
from North Lakhimpur.
at North Lakhimpur police station and therefore he has to be detained there only.
Yes,
Because there would be an order of remand. If he's brought to Hajo police station,
yes.
there has to be an order of remand by the jurisdictional
The
magistrate.
concerned jurisdiction, yes. True, but that those documents are not there. And
No,
instead
it
of
is there. That's why we are saying that it is there. The report before the judicial magistrate first class
Hmm.
reflects that.
yes, my lord. No, what I am saying is that he ought to have been taken to Hajo police station. He was not kept there. He was initially kept at Baihata Sarili police station, then at North Guwahati police station, my lord. Admittedly, my lord.
No, because you see, once a person is arrested in a jurisdiction of a particular police station,
True,
he can't be shifted.
yes, but they have done so here, my lord. And they admit so, my lord. It is
No,
there.
you see, bringing him for police investigation to a different jurisdiction,
Hmm.
that does not require a order of the magistrate.
Yes.
But if he has to be kept in the night, he has to go back to the same police station where he has been arrested. That is what we understand.
Yes, we also understand the same way, but the police authority itself says that due to law and order situation apprehending at Hajo police station, he was kept initially at Baihata Sarili, then in North Guwahati police station.
No, we are not being able to follow your version. Where it is that? Where is that
My lord,
statement?
yes, Lordship will kindly come. Page number 34.
Pardon me, page number?
Lordship will kindly come to page number 43. 43, my lord, of the petition. May I read it, my lord? I would like to report that one Sanful Ali, that is the deceased, son of so-and-so, village so-and-so, PS Hajo, was arrested in connection with Hajo PS case number 1993 of 21 under section so-and-so. Post arrest, he was kept at Baihata Sarili police station and North Guwahati police station as keeping him in Hajo police station would have led to law and order situation in Hajo area.
Correct. No, you see, please come to the next page,
Yes,
page 44.
Yes.
First paragraph, last 3 lines. On 2/12/2021,
yes, my lord.
on interrogation of Saiful Ali, was declared arrest at North Guwahati police station at 8 p.m. So you see, whatever has happened in between, but he was shown arrest in this police station.
Yes, at 8 p.m.
And therefore, whatever the police writes, he
It
has to be brought into the same police station for the, if he has to be remained at night. Because otherwise there has to be a jurisdictional transfer of a arrestee from one police station to another police station.
True.
So whatever they write, irrespective of whatever the police has written,
True.
but the fact is that he was arrested
It's shown to be arrested on
at 8 p.m. at North Guwahati police station on 2/11/2021.
Yes, fine.
But I have not found anything in the Assam police manual which prevents a police from taking him to the crime scene.
Yes, ma'am. True, my lord.
Yes.
Yes, after his arrest, my lord, it is stated by the police authorities that on interrogation, the investigation authorities
Just a moment. Page 7 of your this writ petition,
my lord,
paragraph 4, last 3 lines.
my lord.
Accused Sanful Ali, his brother Ismail Ali and Narjur Ali were arrested by the police on 2/12/2021 and forwarded before the GMFC Hajo on 3/12/2021.
Lordship.
So this is your own statement that within 24 hours of the arrest, he was produced before the magistrate.
Yes.
Hmm.
Yes.
Yes.
Yes. My lord, at North Guwahati police station, the IO of the case interrogated the deceased accused. And my lord, it is stated that there were 2 other persons who were not named in the affair, but they were involved in the, my lord, offense. And they were hiding somewhere in Udalguri district. So, my lord, to apprehend those 2 accused persons, this deceased victim, my lord, the police authorities had set up a plan to take this deceased victim to Udalguri And at around, my lord, 2 a.m. in a night, they, my lord, started. And the team comprised with the IO, the additional SP Kamrup, and some other constables. And after traveling from the North Guwahati police station to Mannakata Road, my lord, the deceased victim accused of his bowel movements. That's why the vehicle was stopped, and he was taken to a nearby stream. And my lord, he pushed the concerned constable and tried to flee away. Now, my lord, they say after some time they could see something floating in the stream, and it was pulled out, and it was found to be the deceased victim, who has then taken to Tolaram Bafna Hospital, and where he was declared dead due to drowning, my lord. So this is the case of the, my lord, police authorities. Now the preliminary postmortem report that we have, my lord, annexed, and it starts at, my lord, page 46, annexer 6. And the opinion is at, my lord, page 50, last page of the repetition, my lord. Page 50, my lord. Opinion regarding cause of death is kept pending till the receipt of chemical and toxicological report from DFSL Kahilipara. However, the injuries present over the body were antemortem and caused by blunt force impact. So Lordship will kindly mark this, that the injuries were caused by blunt force impact, my lord. Now, immediately after the death,
Just a moment.
yes, my Subsequently, in the final,
Mr. Nath, going by the postmortem report at page 47,
My lord,
we think the petitioner would be entitled to compensation by the state. See page 47.
the injuries, right?
47.
Or 46, sorry.
Column number 2, probably.
Lordship.
Because incidentally, I have some experience in swimming in this Digoli Pukri tank. Earlier time when there was no swimming pool here. So at that time I used to swim here in this Digoli Pukri tank. And playfully we used to go down. But this bottom of this Pukri would not cause any hurt. But that time there may be a difference between a living person and a dead person. But still going down and getting the bruises at page 46
My lord.
is just not possible. Even if a person dies and falls into the bottom of the water body, this injuries of this nature.
My lord, that particular place as has been described in the affidavit, but there are some small bushes, my lord, and it was a river and having some
But you see, this will never happen.
boulder and all, my lord.
This will never happen.
My lord, kindly see the page number 49, my lord. Muscles, bones, and joints. There is no disease, deformity, fracture, or dislocation, my lord. There is nothing. And the description of the details, all these bruises, abrasions, these, my lord, sudden, because he jumped in that water body suddenly, my lord.
Laceration measuring 2 centimeter into 0.03 centimeter skin deep over the forehead, 7 cm left to the midline.
Gotcha.
Contusion measuring 17 centimeter into 0.3 centimeter present over the root of the neck in frontal aspect. Now with this 2, please come over to at page 46, serial number 2. Now please come over to page 47.
My lord.
Vertebrae, pre and paravertebral muscles at level so and so, so and so, so and so are contused. I hope you are able to draw the link. The vertebral muscles are generally the muscles of the upper torso, neck upwards. So it has a contusion. Now, number 3, contusion measuring so and so over the left hand side of the chest. Abrasion measuring so and so is present over dorsum of the right hand, 4 centimeter below right wrist joint, and 6 centimeter above root of the middle finger. Bruised abrasion measuring 8 centimeter present over left thigh from the anterior superior iliac spine and 70 centimeter above knee. Bruised abrasion measuring so and so present over lateral absolutely left thigh. Bruised abrasion measuring 9 centimeter over the posterior aspect of the left thigh. Means if while running he falls front.
found in the left side, my lord, because all the injuries, my lord, kindly see the first one
We
also,
understand, but look at this.
left forehead,
Eight number is bruised abrasion measuring so and so present over posterior aspect of left thigh.
my lord.
So in the posterior, he can't fall front and back at the same time.
No, cannot. Malad, one aspect they have also indicated that when the body was malad, they have dragged the body to take it up. Some malad bruise marks may have caused. That is what malad in the affidavit we have
But
said.
then the police is taking a risk if they are dragging a body like that.
Malad,
We don't know how this has happened.
true. They said that too because the body was there. They found and when they dragged because some bushes were there, so some bruise marks may have been taken place at that point of time. They said that. My just I'm indicating malad that there is no such malad the serious injury in the malad postmortem report which has caused the death malad apart from drowning malad. Because this bruise and malad this abrasions these will not cause death of a person malad.
Where is the cause of death?
Later on, it says that due to asphyxia, my lord.
Where is that? Asphyxia may happen if he is drowned.
Yes,
It's quite a possibility.
yes. Because drowning is a severe form of asphyxia where, my lord, oxygen to the lungs are cut off because of fluid in the mouth and the nostrils, my lord.
Because asphyxia is of generally understood in two ways. Number one, it may be strangulation, but marks of strangulation is not there.
No.
It can be, my lord, his head can be put down under water by force, by pressing, so that he suffocates, my lord. Strangulation may not be there, but his head.
But then that would reflect in the postmortem report, I think.
No, that's why, my lord. What I'm trying to say, there are some inconsistencies, how the event, in the manner in which the death occurred, my lord. Because the IO, that is his adoption,
Final report.
files an FIR and lodges a report before the concerned judicial magistrate.
Final
And there are two versions, my lord.
Just a moment.
report.
Mhm.
My lord.
This police personnel who were there with the deceased, were they medically examined for any injuries? No.
Persons, my lord, during inquiry, statements have been taken, but medically, my lord, I have to see. My lord.
You see, there is a reason for us asking that. I'll just give a general idea, then we'll come to specifics.
Lord.
You see, drowning of a child is possible because he may not know how to swim, how to come back. But for an adult, it is normally considered rare. It will happen for various reasons. One is when you touch the water and it is too cold, hypothermic shock sets in and he may have a heart attack and then he may die immediately. That can be immediate. But then the postmortem report will show that. The second is that if otherwise an adult has to die of drowning, then there will be signs of some weight put on him, or he's given some intoxicated substance or drink so that he loses his control over himself and gets drowned. Third possibility is that somebody must have pressed him into the water. Here we get in this postmortem report injury on the occipital region. So therefore, there is an injury in the occipital side, which is from the midline to the ear. That is the occipital region. This is a portion which, under normal visualization, we don't see that a person drowning there will get an injury in the occipital region. And therefore, if somebody is pushing him, another person into the water for the purpose of drowning him, there will be signs of resistance. He would be fighting for his life. And therefore, an injury to a person who is causing that particular push into the water will have some sort of injuries.
Gotcha.
So that is why from that general the specifics we are coming that this is the reason. If the police personnel are not taken for a medical examination, then the evidence that he was a part of the struggle in drowning of a person, that will not be there. So it's an evidence lost. We'll take a short break and come back.
Malad.
Mr. Sharma, that request for listing a matter today, that will not happen because it will come tomorrow. Mr. Upaman Hazarika was there. Just tell him if he comes. No, that's okay. You don't have to go out. If they come, just tell them.
I've seen him
Yes.
outside.
It's okay, but
But in our affidavit, in opposition and the other records available with me, I have seen, Malad, there is no indication that whether they have examined the police, medically examined the police persons or not. Malad, pursuant to the last honorable court's order, a report has come in the seal cover, Malad. It is there. The record of the case. Case record to hana gaya.
this case to 22.
Case record.
Just see a record in a seal cover.
Case records. One case record has come. That may have some indication, Malad.
This case to 22. Sacho. Judicial mistake first class, Raju, Kamru. Report in seal cover. That also contains the inquiry, judicial inquiry.
Judicial inquiry.
No, just check the
No
record.
details, no details.
If there is a report in seal cover,
Me-
there was a record.
Miss case number 2 of 22 containing the judicial inquiry report.
We have also included the judicial inquiry. Private edition.
Seal cover to अपने report है, record is about us. Some record has come. May not be in the seal cover, but a record has come from the court below. Malad.
No, this trial court record is here.
Well, if that contains something, Malad, I don't know. Malad. Otherwise, in my record, Malad, it is not reflected whether the police persons were medically examined or not.
First time, sir. In addition to that, legislative inquiry, one judicial inquiry is also there, conducted by JNXO. is the new IPC, Indian Penal Code, IPC. So this is CRPC, it's not here. See, criminal procedure law. This could be better. This Hajo PS case number 1993 is what matter?
My lord, in connection with, it was lost by Sarbat Ali that his son was abducted and subsequently murdered.
Okay. We're just trying to look into the record. Something which is,
Well, there was a judicial inquiry by the
that's not, you see, the judicial inquiry starts with the registration of miss case number 2.
two of
Yes,
22.
but this record is tagged with 1993. Why?
Object of the inquiry, well, they have said, the inquiry report we have annexed at Annexure A, well,
Annexure A, page.
Annexure A to the affidavit. This is an additional affidavit filed by the SP. Well, the
SP is
my-
respondent number
4,
4.
additional affidavit of the SP.
Is at page 87.
Malad. Object of the inquiry, the court below has noted. The judicial inquiry was initiated by registering the same as case number miss case number 2 of
No, but why-
2022.
The question is why it is being tagged with 1993.
Lordship. Malad,
Because the records show that some accused is there. Accused will not be there because this is only a magistrate inquiry. There is no accused.
Under under section 176, Malad.
171A.
Lodge.
So there, ideally, there would be no accused person. Correct. It's just a inquiry by the magistrate.
In
And
case
he'll
of
give its
that,
report.
in case of that, Lodge.
But this is tagged with the records of 1993. And the question is why?
Malad, possibly, Malad, in connection with the case, Hazur PS case, that is why it is tagged there, Malad. Because this paragraph said that in order to probe into the custodial death of one Sanful Ali, arrested in connection with
That's
this
an
case.
independent inquiry. It should not be tagged. Ideally, it should not be tagged.
Right. The inquiry was conducted as per order of the learned CJM, Malad.
Offshoot of the main case, perhaps that is why it got tagged. In connection with the death,
That,
was a UD case registered?
yes,
What is the number of that UD case?
UD case was registered. In our affidavit, we have said.
We have your affidavit.
Malad. But this is the additional affidavit.
Yes.
In the affidavit in opposition, Malad,
Yes, yes.
I find that.
By Hitesh Chandra Roy.
Hitesh Chandra Roy,
Yes, we have that.
Lordship.
That is page 86,
UD.
87.
The first affidavit in opposition, Malad, affidavit in opposition filed by 4. And internal page, Malad, 3, UD case number 10 of 2021.
Okay, that is at page 51.
Lodge.
51, paragraph.
Paragraph number 4, it starts at internal page number 2.
Yes.
Next, kindly come to next page, the second para. In this regard, the respondent number 8, IO, lodged an FIR at North Guwahati PS case, which was registered as North Guwahati PS case number 194/2021. And an investigation of the said case is underway. Further, one UD case number 10 of 2021 has also been registered at North Guwahati PS case number, and the same is also under investigation.
Yes. Means I don't know the procedure. This is lack of my professional experience in that UD cases. This inquiry under 176, 1A. It should be tagged. Ideally, it should be tagged where? In a UD case.
Unnatural death. Yes, UD case.
But here it is tagged with this record of 1993.
Lodge.
That's why the query is why.
Lodge.
Wait a minute. And what is annexure A? Page 90 is that report.
Yes.
Case 2.
Yes, bro. This case 90.
You see, can you come to page 93?
My lord. Yes, my lord.
Third subpara on 14/5/2022
My lord.
at 1:30 p.m. I, along with my attached PSO, so I prepared a rough sketch map of the place of occurrence and tagged the same with the case record. I also took some photographs and tagged with the case records for my personal reference.
Gotcha.
Now is that that photographs are here.
Well-
You're sending it across to you.
Gotcha.
It is in the records of the
The
miss
entry-
case.
The records of the miss case, my lord. Gotcha. It would be very nice. Not- I mean, you did 57 days. No, 90 start was 93. Well, in this inquiry also, the police persons who were present, they were not, statement was not taken.
The matter without, in fact, earlier perusal of the records. I did not go through it. So I'm finding it. If I'm not acquainted with the records, that's the difficulty. This is the photograph. Now, as per the magistrate, it's a photograph taken of the place of occurrence. Now, please look at this site. Next page. The water body is there. And there is the road, what you call the road marker and the pond, that water body. You see the difference. Now, prima facie, this does not show that there are stones, boulders, and then he will fall down and get the injuries of that sort. And if photographs at page 1, this page is referred to, then definitely the police would have shot this man if he was running away. Next page, first photograph is a possibility that from the road he jumped and then ran away and fell into the pond. But this injuries remain unexplained. The terrain is not there.
It seems.
The depth of the water body conducive for drowning.
No, we don't know. Because these are the things which the magistrate should have recorded. If this is the place where the dead body is retrieved, just Mr. And I just have this record again. You just try to find out the sketch map. It would be in the first file, in the index. The Inquisition member send it tomorrow. Sorry, I've spoken to the registry.
Supporting. Not supporting. Not supporting.
My lord, while my learned friend presented the record, may I just point out one factual inconsistency if you lordship permits. After he was declared dead at Tolaram Batna, the IO Sri Jadab Sharma, who is personally by name made party in this petition, he initially lodged an FIR, where he says, my lord, while the accused deceased was taken for nabbing the other two culprits, in the team, additional SP Kamrup was also there. In the second report before the judicial magistrate, he says he was not there. He informed him, then the additional magistrate, additional SP came. In the judicial inquiry also, this
No, there's also a report somewhere where a statement of this additional SP is recorded.
yes.
He said that he was deputed to go to Lakhimpur. So his presence is not there because the documented presence of the superintendent of police is not at the place of occurrence.
Here I am talking about additional SP. The IO himself says in one FIR that he was there, while in the other my lord, he said that he was not there. He informed him, then he came. And in the judicial inquiry also and the magistratal inquiry also, discrepancy is there. I will show that.
Okay.
The
Well,
presence of additional SP.
A rough sketch is there, but from this one, I could not.
You can identify the place of occurrence.
Did it? Police station level.
Yes, Whatever I was saying, that doesn't change. Say, you can say that. Say, total. No, this is it. Hello, hello. Asset. Service. Okay. Price. Advice. Advice witness. Advice witness. Yes, please show us the discrepancy in that evidence of
Yes, ma'am.
the IO.
Yes, Lord will kindly take up the writ petition, my lord.
But Mr. Nath, this inquiry report, we are not satisfied. Because that is not a sketch.
That is not a sketch, my lord. From that, my lord, we cannot come out, my lord.
And she's a judicial magistrate under our supervisory control.
Lordship, we could not make out anything, my lord, where the body was found, where is the road.
And there's something more to it. We come to page 91.
Lordship.
Last paragraph, procedure of inquiry. Just
Before,
read that.
before the onset of inquiry as part of the process, public notice was issued in one vernacular newspaper, that is Assam Tribune.
Is you can stop here.
Notice is there, my lord.
The incident is at which location?
My lord, the incident. one-
Possibly, but the next page, it is written as not Lakhimpur. It should be not Guwahati, possibly. Not Lakhimpur.
No, that death took place, my lord, while he was being taken to Dalgori via Mannakata Road,
From not
Kali Mandir, Rajadwar.
from not Guwahati.
Kali Mandir, Rajadwar. There the vehicle was stopped.
Correct.
Kalimandir Rajadwar
Yes.
Correct.
at North Guwahati.
At
Yes,
not
and
Guwahati.
not Guwahati.
Rajadwar is
Not
very
Guwahati.
adjacent to here.
Not Guwahati.
Not very adjacent to here, adjacent to that.
Yes.
It will be just opposite that Jahajghat, this one, Supreshwar, just opposite the Supreshwar, that is Rajadwar.
Yes.
Rajadwar, this is Ferighat, Rajadwar this side, and in the North Guwahati also,
Just opposite.
Rajadwar Ghat is there.
Because that raid ultimately went to North Guwahati, sorry, North Lakhimpur.
Hmm.
Yes, where is that discrepancy you were just
Yes, my
referring to?
lord. Lordship will permit me to place that. Lordship will kindly come to page 43 of the writ petition. Page 43. After the deceased victim was declared dead at Tolaram Bapna, the IO, SI Jadab Sharma, lodged an FIR before the OC North Guwahati PS on 3/12/2021. My lord, the third para, may I read it, my lord?
Yes.
Accordingly, as directed, self along with party and staff took the accused from North Guwahati PS and proceeded towards Udalguri via Mannakata Road. After traveling for around 50 to 20 minutes, at a place near Kali Mandir Rajadwar, the accused complained that he had to pass latrine and could not control his bowel movements as he was suffering from severe loose motion. We stopped near some bushes with a river tributary nearby. However, after reaching the bushes to pass latrine, the accused pushed the on-duty policeman and ran towards the water body and jammed into the same in order to escape from the custody. My lord, kindly mark this line. Immediately self informed the matter to additional SP headquarters Kamrup who rushed to the spot with more party and search was conducted to trace the accused. Ultimately, he was found and brought to the bank in unconscious condition and immediately shifted to sensor.
Yes.
Now, Lordship will kindly mark this line and turn to the next page, page 44. Again, this is a report filed by the same IO, Jadav Sharma, in the Honorable Chief Judicial Magistrate First Class Court, Magat Hajo.
Same day, 312.
Same day, and by the same officer.
Yes.
My lord will kindly come to third para, page 44. Accordingly, as planned, self along with additional SP Kamrup headquarters and staff took the accused from North Guwahati PS and proceeded towards Udalguri via Mannakata Road, Sensor. So here he says that the additional SP is present with him, with the team. And on the same day in the other, that is the FIR lodged before the OC North Guwahati PS, he said he informed the additional SP who, after getting the information, rushed to the spot, my lord. And this same inconsistency, Lordship will find in the judicial magistrate report vis-a-vis the executive magistrate report. One says that
Just a moment.
yes,
Yes. Now you're taking us to which page?
now I'm taking the lordship to page 91, the additional affidavit filed by the SP, where the judicial inquiry report as well as the executive magistrate inquiry report is annexed, my lord.
91.
It's a part of the judicial inquiry report. my
Yes.
lord. My lord, 14 line from the top, my lord. And accordingly as planned. Page 91.
Just. Executive Procedural. Yes, you were showing us some page 90.
91. No, I
90.
was indicating, my lord, the discrepancy or inconsistency
Yes, yes,
which I have just now pointed out
yes,
also gets reflected in the report of the judicial magistrate
yes,
vis-a-vis the report of the executive magistrate. my lord.
yes,
The judicial magistrate at page 91 has recorded that the SP, I along with the SP took the accused deceased,
11th line,
14th line from the top. my
14th
lord.
line,
And accordingly,
and according to as planned. Okay,
the,
yes,
the IO along with the SP headquarters, Kamrup, and staff took the accused from North Guwahati PS and proceeded towards Udalguri via Mandakata. And thereafter, they have also annexed the ministerial inquiry report. The ministerial inquiry report starts at 98. The relevant portion is at page 100, my lord. At page 100, 19th line from the top, my lord, 19.
Yes,
The line starting from the police personnel tried to search.
yes.
The police personnel tried to search for the accused person, but as they do not have any equipments to search in darkness, the accused could not be found. SI Jadav Sharma immediately informed the additional SP headquarters, Kamrup, about the incident. On being informed, the additional SP headquarters reached the spot after 20-30 minutes with some additional police constables and high-power searchlights. So one hand, the additional SP is there. One hand, the additional SP is not there. It was a planned, my lord, raid without any torchlight and anything, my lord. So it gives a inference that, my lord, they're trying to cover up or make up something as an afterthought. And here, my lord, a life has been lost. Article 21 has been infringed. The Honorable Supreme Court, as your lordships knows, I know, did not rated in DK Basu and Nilavati Behera, my lord. You may be an accused, you may be a convict. Even convict, your liberty is curtailed, but not right to life under Article 21. That has to be protected, my lord. So here, apparently, my lord, the report, there is an element of afterthought, my lord, because it is inconsistent. The same officer giving two versions, my lord. And my lord, in my humble submission, who, my lord, pulled him out from the police official, they should have specifically stated constable or officer so-and-so swam across the stream and pulled him out. His statement was very much necessary. No such evidence, my lord. How the dead body, who pulled him out?
It has to be there. There has to be a memo.
No, my lord.
They would be there.
No, they simply say we pulled him out. We is vague, my lord. Has to be specific. And within 10-20 minutes, they found the body floating, my lord. After drowning, within 10-20 minutes, the body floated. My lord, just to yes,
my lord, can this be taken on other day, my lord? At two, my lord, some one part hard matter is there, my lord.
You may continue there. We'll hear him for some time.
Lordship,
Mr. Sharma is here.
lordship.
We can't close the matter today because since I did not peruse these records
Lordship.
earlier.
Okay.
So,
I'll just come back after that.
yes, you
Lordship.
complete your part.
Lordship.
Mr. Sharma would update you.
All right.
There's no difficulty in that.
Lordship. Battery में हो गया ना? Battery वो है, सोना मेरे पास। Default बना हुआ, कोड है।
my lord. My lord, I was pointing out to this honorable court some of the inconsistencies which is discernible from the records. Another instance.
Oh, just a moment. Mr. Aman and others who are there for foreigners matters, I don't think we'll have time. This is going to consume some time.
Sir, on detention matter, it has come up many times, my lord. Ex parte matter. I would be grateful if your lordship may take a day, my lord. It has come up many times, but because of paucity of time, it could not be taken up, my lord.
Okay.
The item for next matter, my lord.
Okay, just wait. Before rising, we'll try to take it up.
I'm grateful, man.
Which page was the postmortem report?
My lord, a postmortem report was, the preliminary postmortem report starts at page 46. But the final postmortem report is not on record. They have not brought it on record.
No, that we have seen. It says there's no poison.
Yes, no poison, no toxic. And
So
death was due
because,
to asphyxia.
that doesn't help us. Page number 40,
It starts at page 46.
46.
Yes,
Okay.
of the writ petition.
Yes. Yes, Mr. Patwari.
Yes, in respect of the kidney also, at page 48, the right kidney is found to be contused, left kidney is healthy, my lord.
Yes.
And as your lordship knows, contusion is a bruise or wound, my lord, caused by direct blow or impact to the body.
Okay.
Yes. So, my lord, I was addressing this honorable court on the inconsistencies, my lord, that are apparent on the records. One of such inconsistencies is, my lord, the IO Sri Jadav Sharma has filed an affidavit.
You will,
Yes. The
you will look this,
Yes.
you meant something.
lordship.
When you refer to right kidney,
Yes.
I just put a query where is placed.
Yes.
So that is the placement.
Right.
Now you see the confusion may be for some other cause because there is no external injury.
There is no external injury.
So therefore, if there is no external injury, the contusion caused to the kidney may be for some other factors we don't know.
Yes, ma'am.
It's just below the liver
Below the liver.
and behind the abdominal wall.
It's well protected.
It appears to be well protected.
Protected.
Because then if there is no corresponding injury to the liver, it's just below the liver. So therefore, a hit only to a specified right kidney without any other external injuries. So
That's
it
not
not be a
corroborated.
conclusive proof.
That's not corroborated. Yes. Lordship, I was just pointing out to your lordship the inconsistencies. Now, my lord, lordship has noticed that the state authorities have taken a stand regarding the injuries as mentioned in page 46 of the postmortem external injuries. That while recovering the body, there were thorns and bruises which could have caused. Now, as per the affidavit of the IO Sri Jadav Sharma, now again here in this case also, he takes two steps.
Okay.
At para 9, he states, while the accused was arrested, he resisted the arrest. That's why those injuries may have caused. And at para 12 of the same affidavit, he says, no, while recovering the body, there,
Where is that affidavit?
yes, the affidavit, my lord, of
Jadav Sharma,
Rashmore number 8, Jadav Sharma.
page 60.
Page 60, my lord.
It starts from 59. 60 is where it starts.
Yes.
Yes.
Lords will kindly turn to para 9. Para 9 starts at internal page 5. Lords will kindly turn to internal page 6. Has your lordship got it?
Yes.
Yes. Third line from the top.
Yes.
The answering deponent begs to submit that as the son of the petitioner forcefully resisted arrest, he suffered some injuries in his body, and the same is reflected in the medical officer's examination report dated 2/12/21, which is available with the case diary of Hyderabad Police Station case number so and so. Now, my lord, lordship will kindly turn to para 12 at internal page 11.
Just a moment. Just see that 193321.
Yes, madam.
This man was arrested on 3rd. Was produced on 3rd. What is the name of the deceased?
Thankful Ali, madam.
Please give the name of the deceased again.
Sanful Ali, SANFUL Ali.
SANFUL.
Yes, Sanful. Sanful Ali. Yes. That's why I was referring to the affidavit of the Ayog. Possibly, I have referred to para 9.
Examiner. Statement of. As per Jadab, so here, Jadab Sharma. 212 with arrest force, 212. তার আগতে অ্যারেস্ট করার লগে লগে কোনটা হসপিটাল এটা দিবেনা তো অ্যারেস্ট করলে যদি বিয়ে অ্যারেস্ট করলে হাজত এই লক্ষ্মীপুর এক্সামিন কি হয় বিয়ে করে অ্যারেস্ট করেছে not Lukhimpur.
Near my
Near Hajo,
not as near Baihatasari. Bezera.
near Bahatasarili,
Just crossing Baihatasari.
Bezara,
Towards Mongoloi Road.
on the Mongoldi Road.
Ah, yes.
Sampulari along with policemen
If you take you have to have it.
were settled, were arrested in connection with Hajur business numbers management
কিন্তু he was
with the help of
Bezera to
Lukhimpur
Mongoloi
police
Road.
station from Lukhimpur district. Early morning on 2/12/20.
কিন্তু it is not.
Was arrested in connection with the escape of Baihatasari. ये क्वेश्चन एफिडेविट লখিমপুরের পর অ্যারেস্ট
Mr. Patwari,
Gotcha.
can you tell us the place where the deceased was arrested?
As per record, not Lukhimpur, man. They their own statement.
No, but any document to that effect?
No, my lord, because he was kept on, he was shown arrest on 8 p.m. on 2/12. Thereafter, he was taken to
Please come to page 43.
43. Of the writ petition, my lord.
of the writ petition.
Yes, my lord. This is the FIR lodged after his death.
Yes, this is by Jadav Sharma.
He is the IO of the Hajo PS case.
Whatever be, but please read the starting.
I would like to report that one Sanful Ali, son of so-and-so, was arrested in connection with Hajo PS case number so-and-so. Post arrest, he was kept at Baihata Shariali police station and North Guwahati PS, as keeping him in Hajo PS would have led to law and order situation in Hajo area. On 2/12/2021.
You can stop here.
Yes.
You see, now the place of arrest, in the FIR doesn't say where he was arrested. Therefore, with all presumption, is that he was arrested within the jurisdiction of this police station.
Yes, ma'am.
Of Baihata Shariali.
Then the reports are manufactured. The
Yes.
affidavit will be false.
Yes.
Of respondent number 4.
Interrogator, the accused is not talking with PS, not lodging.
Because you see, his here there are when Mr. Nath comes, please tell him that 2 or 3 major inconsistencies which are coming out.
Yes.
Number 1, the writ petitioner says in paragraph 4 that the petitioner was produced before the magistrate. Records show that he was not produced before the magistrate. In the magistrate, a report was filed that he had died on 3/12. Correct. Now, in this affidavit, it is said, that is one. Second, this affidavit, it is said that the the deceased registered the arrest and therefore he got an injury. Correct. In this record, I have flagged one document which shows that he was referred to Bezera CSC. Now there are 2 questions here. Number 1, can the state police, under any mechanism under the CRPC, arrest a person in Lakhimpur and produce him before the magistrate at Hajo? Because he has to be produced before the court where he was arrested.
Transit remand.
And transit remand. Correct. So this appears to be prima facie a manufactured record. That is the second part. You see, Mr. Sharma, the third part is, which is interconnected to the second question, is that in the back page of the reference, of the referral of the arrested accused to Bezera CSC, the back page contains the medical report. That medical report is signed on 12/2/22. The death is
3/12.
3/12. So either, but nobody is questioning this document. Now, therefore, you see, there's something more interesting. You look at this record.
Well, since the petitioner is not privy, he cannot challenge.
No, we understand. We are not saying that it will last flag. It is the last flag of this record. Yes, this is the first page where this man was sent to Bezara PSC. Correct. Now turn to next page. Down below is the signature. Down below is the signature of medical officer. Signature is either 12/2 or it is 17/2. I can't read.
7, 12, no? 17/2. Maybe 17/2, my lord.
17 or 12, I don't know. I can't read. So therefore, I am not venturing to strain my eyes. You see the interesting part. That is the fourth one. The nature of injuries. Nature of injury. No, in that page only.
Yes.
Yeah, back page. Nature of injury. First column. Scratch mark. Correct. In the forehead. Scratch mark is 1:1.
1:1.
And this interestingly, the scratch mark of 1:1 is not there in the postmortem report. Or the other alternative is that this is a report of somebody else. It is photocopied like this.
Photocopy.
But normally it cannot because it's a continuity.
Pertains to a particular case.
No, not that. In this case, there were 6-7 accused.
Yes.
Let me see,
Something may have jumbled up, but 12 to whoever was produced before the medical, we don't know. And you see, the first to the first question, the police sends a requisition. There is no date. The date when the treatment, when the medical officer saw the patient is not there.
Yeah, my lord, Bezera CSC.
No, Bezera, but the doctors and all, they don't give the signature and time of the what do you call, the time of inspection when this accused was actually seen is not there.
Time, date of examination. 2:12.
It's just not there.
Time and date of examination. 2/12/21.
212.
2:12. Yeah, last.
Okay, then this must be him only. So examined on 212. Okay, I missed out that.
Last. And examination. 2:12. Last portion.
Oh, date and time of examination.
Yes.
9:40 a.m. to 12:21.
2:12.
I said,
Yes.
let's go.
Yes, the lot of 22.
2:12.
At range.
Not of that injury. This was not of it. So therefore, this report says at 9:40 a.m. he had only one injury, scratch.
Yes.
My lord, the doubt over his place of arrest still remains. Because the
No, no, I really have not gone through the records, so therefore I find it very difficult.
Very difficult.
because in his affidavit also, Jadhav Sharma IO, he himself states at para 6 that he was arrested from North Lakhimpur. Para 6 of Jadhav Sharma's affidavit. Paragraph 6 of Jadhav Sharma.
Yes, we have seen that, but
he-
it has to match.
And at para 12 of Jadhav Sharma's affidavit, he again says the injuries are due to my lord, caused by due to my lord thorns and bushes at the place of occurrence. Para 6 for place of arrest, that is North Lakhimpur, of Jadhav Sharma's affidavit, my lord.
It's 45. If I have to say, bro, if I have to say, yes, lead the live in the area, works in the still not working. Oh, no good. পয়সা নাই ওই দেবো পয়সা খালি একবার বিচাৰিছিল মই গৈ আছো দেখাই দিলো দুই বাৰত পুলিচ পোষ্টমৰ্টম কৰিছিল 17/12 ডেট অফ এক্সামিনেশ্যন 2/12 আছে দেখাই দিছো লাষ্টত আছে
Yes.
So, my lord, the record belies the contention at made at para 9 that injuries was caused because he resisted arrest, as stated in para 9 of that affidavit. And again at para 12 of the same affidavit, my lord, the same officer states as follows, my lord. Internal page 11, para 12 of Jadav Sharma's affidavit, my lord. That with regard to the statements made in paragraph 8, 9, 10, 11 of the writ petition, the answering proponent begs to submit that the allegations leveled therein are false and baseless. It is pertinent here to mention that the tributary where the accused jumped into has huge quantities of thorns, branches, and even some boulders both sides as well as on the banks. Lordship has already perused the photographs, my lord. It belies the statement. The accused Sanful Ali might suffer injuries either when he fled away and jumped into the water, or maybe when he was brought to the bank to the tributary which is full of thorns and bushes. This is the explanation given for the injuries by the IO. And it also it is also in contradiction with the preliminary postmortem report, which says the injuries were caused by blunt force, not thorns and
No,
bushes.
blunt could anything be blunt force. You see, even if you fall, the impact would be blunt force.
Yes,
Because when somebody is doing a medical examination, the examiner does not know how he got the injury.
true, man.
So he will say it is blunt force. Maybe now you are handing over us to some document. You strike this
Yes.
post. You
Accident.
may get a blunt force injury.
True, man. But however, my lord, still there is, my lord, inconsistency in his own stand, my lord.
Yes, you have highlighted these points.
Yes,
You take a note of that.
yes. And my lord, there is another inconsistency. I don't know, my lord. In the judicial report, my lord, where the opinion of the judicial officer is reflected, the judicial officer refers to certain witnesses, but where are those witnesses? Nowhere to be found, my lord, at least not in the affidavit. Who are those witnesses? It's not known, my
Oh,
lord.
there are 28 witnesses examined.
No, my lord,
Examiner.
which witness is whom? How do you know, my lord? The report does not.
No. You see, there are that is for you to take an appropriate call. You see, number one, when it is an investigation with regard to the death, then definitely you can apply for a certified copy and get it. Number one. On number two, before the commencement of hearing, you would have asked that these copies be given to you, provided to you.
My lord, the copy is already annexed to the affidavit.
No, that is the record which we called on the last date.
Yes,
Had this record not been called, we would have not known.
yes, now it is there, my lord.
So now it is there. So,
That is okay.
you see the deficiency in a criminal trial. We don't look at the procedural defect so bad when it is a case of death. Because we are examining a case of death, not of acquittal or conviction.
True.
So
Yes.
the parameters to evaluate the records for the purpose of ascertaining whether the man died of police brutality
Yes,
is in a different pedestal than we examine a case for purpose of
Acquittal or-
conviction where the parameter is proved beyond reasonable doubt.
Yes.
So in a compensation, you can get a compensation only for on preponderance of probability.
yes, my lord. Then if it is in the record, my lord, I will-
28 witnesses have been examined.
Yes. Then my lord, my concluding statement before your lordship will be that both the judicial inquiry report and the ministerial inquiry report does not reflect how it was drawn and how the body was recovered. On these aspects, my lord, the entire report is silent. They have simply corroborated with the two reports given by Yadav Sharma. They simply reiterated that. That means, my lord, in my humble submission, both the inquiries were done in a perfunctory manner without any specific details about the cause of death and, my lord, and the procedure followed thereafter.
Who is respondent number 6?
6, my lord.
One number 6 is the, my lord, officer in charge, North Guwahati Police Station. my lord.
Okay.
Yes. Present.
This it is not there. This Constitution of India.
ট্রানজিট হলে তো অর্ডার দেবো না সেটা পিটিশন আছে এলাকা আছে নিয়ারেস্ট ম্যাজিস্ট্রেট প্রডিউস করবো লাগে
Process.
You see, there are many gaps in the, Mr. Biswas, we are sitting here. uh, Other matters may not be able to take up. We are taking up a custodial death case. So since we'll be rising at 3:30 for the single bench, we may not be take up other matters. We just surprised Mr. Nath. You see what is happening. We were under the impression that he was once he's being his. That's why the first question was why it is tagged with 1993. So 1993 is
Separate.
that it's a connected matter. Now you will have to address us on the point that if the SP and the OC, they say that he was arrested in Lakhimpur. Where is the arrest memo of Lakhimpur? Number one. Because number two, once he is arrested in Lakhimpur, the arrestee must be informed of his rights under the DK Basu's case on Article 22, that he must be informed of why he has been arrested. Where is that memo? Third, once an accused is arrested in a jurisdiction of a particular police station, Article 20, Clause 2 says that he must be produced before the nearest magistrate within 24 hours. Fourth, that when he was taken out of the jurisdiction of Lakhimpur police station, there must be a transit challan or order of transit by a court of competent jurisdiction. That is not there. Number four, without the transit challan, sorry, no, this is fifth, without the transit challan, when you have entered into a jurisdiction of a different police station, where is the first GD entry of being produced in the before the North Lakhimpur police station?
DCL report also mentioned, my lord.
No, because it is not your choice, not the choice of police station, that I will take him to Hajo, I will take him
He was
to.
hiding in
So that's okay. He may be hiding.
He was hiding there.
No, it's okay. You have arrested him there. Now let us think of a different situation. A man did a crime
Yeah.
in Bombay and he has traveled to Guwahati and he's staying here. Now you arrest this person at Guwahati. He was hiding at Guwahati. Now without informing the jurisdictional police station, can Bombay police come and arrest somebody here? And can the arrest be made by a person or a police officer without having territorial jurisdiction over the place? If the person is hiding in Guwahati without informing Guwahati police, can a policeman from Bombay come and arrest somebody here? So this is the sixth query. And the seventh one is, does the police have a choice that I have arrested him, I will keep him in police station A, police station B, police station C? If that choice was there, then transferring a accused from Punjab to what you call Dibrugarh would have been done without the order of the court, without involving Supreme Court, High Court and all.
But there in that report also, magistrate report also is there, my last. 97 page. Magistrate.
But the report we have seen, that is why we are now dissecting it.
Magistrate inquiry report there by ADM Ambo.
Hmm?
Another report also is there, madam.
97.
97. Not 97, we are. Annexer B,
But there can't be two ministerial inquiry reports.
two report here.
One judicial magistrate, one
On
executive. magistrate.
executive magistrate.
Can it be done? Please look at 176 1A.
Uh, 2/12/21 report, my lord. Magistrate inquiry report regarding death of accused Yakub Ali, Nakun Surveyor Village under Hazard PS.
By year?
Page
No, no, that 126, 176 1A.
26.
And 76. Electrician.
Inquiry by magistrate into cause of death. 1. When the case is to the nature referred to the clause 1 or clause 2 or subsection 3 of section 174, the nearest magistrate empowered to hold inquest shall, and in any other case mentioned in subsection 1 of section 174, any magistrate so empowered may hold an inquiry into the cause of death either instead of or in the addition to the investigation held by the police officer, and if he does so, he shall have all the powers in conducting it which he could have in holding an inquiry into an offense.
So 1A says, once such person or woman or custody of the police or any other custody authorized magistrate or court under the court in addition to the inquiry investigation held by the police, an inquiry shall be held by the judicial magistrate or the metropolitan magistrate as the case may be within local jurisdiction the offence has been committed.
There is
1A.
sufficient- Yes.
Correct.
Yeah.
So this ministerial inquiry is nothing.
It's a holding the connection with the matter.
Ministerial inquiry could not have been done.
Yes. Minister holding such inquiry shall recorded the evidence taken by him, connection therefore in matter therein occurred, prescribed accordingly circumstances of the case.
So we can very respectfully say they have spent their good time
Last. In next statement, we are.
in ignorance of law. And once it is in ignorance of law, everything goes.
And my lord, they are.
Now you see, even now if we read this report, page 99. You must make it a habit of avoiding me to read any document. Come to page 99, incident. Saiful Ali during interrogation confessed about murdering Saiful Ali. Now, where is this confessional statement before the police?
Somebody interpreted confused about the.
He stated that a dagger was used. So this is something which is not there in the available in the judicial records. Now a team was formed. He was hiding to arrest so-and-so. After this plan was to so-and-so night escape. Homeguard another 4 persons. The journey towards Khorabari. The accused in around traveling in about 15 minutes. Accused started complaining about his bowel. Now the place of arrest is not given here.
Not given here. Jadab Sharma, and it was instructed by higher authorities to arrest those culprits night
So
hours.
where he was arrested is not there.
The executive plan, I.O. Jadab Sharma was provided with 4 number arms police personnel. Since the plan was to
Yes.
nab the co-accused during the night hours so that their chance to escape and causing of harm.
When it, in the prelude to the incident, it is there, pre-page 98.
Huh?
In the pre-page 98 of that report, page 98,
Hmm.
place of arrest is there. prelude to the, under the heading prelude to the incident.
Okay,
Yeah. My lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line from the top. Two of the prime accused were found and
at
apprehended.
Lakhimpur, okay. Was arrested by
Veteran
team
king.
of Kamrup police at Lakhimpur. It must struggle. That means Lakhimpur police do not know that a person from their place was arrested and taken.
Very nice.
Now this page 100, in the middle, it says police tried to search for the accused, but so-and-so, after being informed, so-and-so, after 20-30 minutes, again search was conducted, and after 15 minutes, something spotted was floating.
Mm.
That means not even 45 minutes, the body started floating. But from that photograph, we can't say that that is a river tributary. Does it appear to be a river tributary? We don't know. This photograph does not show that. Place of incident.
And who recovered the body? Nowhere mentioned.
It's also Indian.
Hmm?
Indian.
Just
To
like that.
place of occurrence, it is.
Hmm?
Which place of occurrence?
into highway तुम्हारा जीवन तो guard वाला highway तो ये तो नदी ऐसा मैंने कभी नहीं
क्या मजा है?
it was
What's Khoirawari?
पानी खाई.
Around after traveling around 15 minutes, vehicle started.
it was photo
What's Khoirawari?
this one यहाँ पे ऐसे guard वाल करना है
बोल्डर सेक्शन में गुजर रहा है. ये तो जो दिखाना है. सुसुराया है ना कि मेरे को ड्रैग करो. करना है नहीं करना.
No, no, education is very essential. Most of the difference. Judicial report.
Total differences, sir. Every legal procedure was followed when transported. The accused was apprehended from Lucknow.
Huh.
And also by taking him for the next such operation. CD football. CD to my age.
In the judicial.
No, no, no.
Judicial
CD
inquiry,
to my-
it to the magistrate inquiry. Judicial of
1193 CD9.
Yes, I get process. Yourself. Right? So you do. Nothing about this. It's a second. Is it 56 2000?
इसमें ऐसा नहीं CD to. नहीं. Faster. On record along with CD material help us to throw the other. CD to मुताबिक.
Annual report available.
Annual report is stated to have been submitted. It is not there.
Why is not here?
But the accused will raise something. এটা তো বেলেগ কেস হৈছে ইডু কেস হৈছে দুটা কেছে দেখো যে ইডু কেসটো হৈছে ইডু কেস আছে লগতে ইডু কেস হ'ব নহয় দুটা কেছে দেখুৱাই দিছে যেহেতু যেটা
This UD case and this father's case, 174 or 194, what is that?
193
194. And what is the UD case number?
UD case number 10 of 2021. Registered at North Guwahati PS.
North Guwahati UD case number
10/2021.
and this, the other cases, not Hajo PS case number.
Haju PS case number 1993.
No, not that. The father's, in this case, the father gave an FIR, that
Yeah.
case. 194 or something.
What next? Others. One 94/24, not Guwahati case
Ah.
number.
North Guwahati case.
Guwahati case number 194/21.
Guwahati PS case number 194,
Stroke 2021.
2021.
One.
CD people say. 1994 CD 2.
1993 which I said.
Mhm.
CD. 1993 CD matitu. CD 2. CD 2 matitu kali duto kasi.
See, her Mr. J. Patwari, run as counsel for the petitioner, as well as Mr. D. Nath, run as senior government advocate, along with Mr. P. Sharma, run as additional senior government advocate for some time. Stop. Next para. It appears that a perusal of the case diary of the following three cases are necessary. You give a dash and then number 1, North Guwahati PS. No, first you say Hajo PS case number 1993 of 2021. Give a semicolon, then number 2, North Guwahati PS UD case number 10 of 2021. Again semicolon, then say and number 3, North Guwahati PS case number 194 of 2021. UD case. UD case CGM.
Possible CD. Is a jurisdiction in state now. Guwahati to the year that Haju.
North Guwahati too.
Guwahati to the year. I mean, what? Of course.
Okay.
Okay,
Next paragraph.
register.
The registry shall send the requisition to the jurisdictional court for sending the case diary of all the three cases. It may be mentioned here in that as per the submissions made at the bar, comma, final form, comma, acquitting the accused has been submitted in North Guwahati PS UD case number 10 of 2021 and North Guwahati PS case number 194 of 2021. And in Hajo PS case number 193 of 2021. What has happened there?
My lord, I have to take instruction. I don't-
It appears that committal proceedings have not been drawn up. And therefore the records may be in the custody of the Court of Chief Judicial, Judicial Magistrate First Class Hajo. Next, the requisitions may be sent by email with liberty to the concerned court to send a scanned copy of the case diary. In the event the physical case diary cannot be immediately sent. Only scanned copy, not original. No, it's only scanned copy of the case diary. Copy placed before the court. Next by list after. Give a fixed date for the case diary. It will be better. 20. Twenty-eighth, 3/20, sorry. 26/3/2025.
Lordship will keep them at a part since the lordship is of-
We may not say because there's some uncertainty. You will suffer more.
since the lordship has taken
Hmm?
the pain of hearing the matter, that's why.
We understand, but there's always an uncertainty this side.
6/26/3.
Deeply obliged.
You have done it not to keep it as a pattern, but since it's a question of custodial death, we had to go through it.
Obliged.
Obliged, lordship.
And because this matter, I don't know why this matter was otherwise delayed in taking up on board. So therefore we took it up.
Item 4.
What a order, my lord, page number 18. Arrested on 7th of August. My lord.
The notice was served as per 35F.
Yes. my lord.
Mr. Sharma.
Lord.
We'll take this matter up after 2 days. In the meantime, we want to know from which place this person has been arrested. Because the stand of the petitioner is that he is residing in the same village
Hello.
and he was arrested in the same village.
Yes.
Because if he is a resident of the same village, then he must have an opportunity of contesting.
Hello.
Lord.
If he was arrested in the same village,
Yes.
for the purpose of service he is not available, but for the purpose of arrest he is available.
Yes, Lord. Yes.
Correct.
Since 1970, all documents from same village, my lord.
From
Since
1970, all village,
all
documents are-
documents, even Gaubura certificate, my lord, the last document, my lord. The Gaubura of the village has given a certificate, my lord. Last page, my lord, page number 49. Otherwise, your lordship has been very magnanimous in releasing all detainees, my lord. Arrested on the same day. I might be released, my lord. Only 1966 they come from different village, my lord.
66 Pampara Nongo.
66 different village, my lord. The grandfather from 1970, same village, my lord. Page number 24. All document Morisa Kandi. And even the father has signed the affidavit, my lord. Same village, my lord.
You were arrested when?
7th of August, my lord, 2020.
7th August.
My lord, my lord.
Okay, we'll release.
Grateful. my lord.
But Mr. A.W. Aman, counsel for the petitioner. Also heard, all the respondents are there. I'm Kalita on behalf of Ms. P. Barwa for PCI. Next, by filing this repetition under Article 226, the petitioner has said the impugn opinion. Which page?
18.
Opinion dated. Ex parte opinion dated 3/4/2021, passed by so and so and so. Thereby declaring him to be a foreigner post 25/3/1971 stream. Next paragraph, the learned counsel for the petitioner has submitted that the petitioner is residing in village
Morisa Kandi.
Marichakandi, Marichakandi, under police station
Kasumara.
Kasumara, Kasumara, in the district of Barpeta. And in this regard, the learned counsel for the petitioner relies on the documents of after 1970, which are annexed to the writ petition, including the certificate issued by the Gaon Pradhan. It is also submitted that it is in his said village that the petitioner was arrested on 7/8/2024, and since then he has been kept in the transit camp at Matia, Gwalpara. And accordingly, it is submitted that he was all along a resident of the same village, but no notice of the proceedings before the Foreigners Tribunal 7th Barpeta was ever served on him. Next, that the letter notice returnable in 4 weeks be issued. Extra copies within 2 days. Next para the relevant records. The next para, pursuant to the previous order, the relevant records of the tribunal is already received. Don't say notice. Say the issue rule. Issue rule returnable. As the records have been received. The records that qualify has been received. Next para. The prayer for bail made by the learned counsel for the petitioner is opposed by the learned standing counsel for the FT matters on the ground that after the ex parte opinion rendered in 3/4/2021, the petitioner had been absconding, and after a great effort by the border police as well as the district administration, the petitioner could be apprehended. First off, accordingly, doubt is expressed that in the event the petitioner is granted bail, he would vanish. Next para, be that as it may, on a statement made by the London Council for the petitioner that the petitioner was arrested in village, let's say Marika
Marisa Kandi.
Mauricia Kandi, and that he has been residing there all throughout. And on further consideration that the petitioner has been taken into custody on 7/8/2024, and accordingly he has spent about 7 months in custody in the transit camp Matia, Gwalpara. Court is inclined to release the petitioner, namely so and so, on bail. 3 conditions are there. Sum of rupees 5,000 to the satisfaction of Superintendent of Police Border, Borpeta. Next, on the next date of listing, the petitioner, the learned counsel for the petitioner. Oh, no, not required. That's not required. Now you see, there's the matter for hearing. And it's in the month of July 2025. But in the earlier matter. No, this
Grateful, madam.